Good morning, good afternoon, good evening. Welcome back. I am Eric Shiraev. I'm teaching international relations, and last time we studied international security. Today we're turning to international law and international organizations. This is a vast subject and topic. Let's talk about what it is. I will also tell you a few words about the principles and sources of international law, give you examples. We'll explain how realism and liberalism see international law and what constructivists and other professionals perceive international law. A couple of examples at the end, case in point. You understand that's just a short period, and you can take the entire international law class within a semester. There are students who study several classes studying the same subject. It's a very interesting subject because some say that, in fact, international law doesn't exist. And wait a minute, one may wonder, how is it possible? We study international law, we have a chapter in international law. It doesn't exist. Some argue it is just it's a weak concept. And I'll tell you why some argue that international law doesn't exist and why they say, why they state this. I believe it exists. That's why I teach, and we will examine these things critically. So let me start with usual sharing screen and usual beginning. I use a quote from late Senator William Fulbright. Many of you heard this name, and this is a fellowship named after William Fulbright, senator from Oregon, Democrat. People come here in the States, and Americans also go overseas, sponsored by US government, and we go overseas to teach and do research so that international scholars do the same. I will read his great statement. Insofar as international law is observed, it provides us with stability and order, and with a means of predicting the behavior of those with whom we have reciprocal legal obligations. That's the important point, very important point. Behavior of those with whom we have reciprocal legal obligations. You have to have somebody and have obligations and reciprocity obligations, agreements, and then you can just act within international law. What if those agreements don't exist? What if they're not reciprocal? That becomes a problem. See, this is about trust. This is about agreements. This is about the ability to fulfill agreements, goodwill, if you will. Because if you don't have a goodwill, if you don't have agreements and obligations, the whole system of international law would likely collapse or wouldn't exist. I begin my lecture always with the case of Israel and the wall. If you've been there, you saw it before your eyes. It's a massive construction. It's a wall which is about 750 kilometers long, and it's quite wide, and has sensors and the different roads and barbed wire. And people have to go through special checkpoints to go back and forth in the Palestinian territories or Israel. General Assembly of the United Nations a long time ago, back in 2003, and then UN International Court of Justice decided by a majority of vote that the wall was illegal. And the courts obliged Israel to cease construction and repeal laws associated with this. Israel disagreed. And scholars and the position of Israeli governments and Supreme Court of Israel ruled that fence was legal. One of the arguments is as a temporary construction, and countries may build such things on temporary occupied territories, and it should go away. Of course, many others disagree. Different positions about the wall. Case in point, so there is something going on, and there's a decision of a legal organization about this project. Do countries have to follow those decisions or not? If they're sovereign, well, they're sovereign by definition, because sovereignty means you decide yourself. There's no above authority, and there's nobody who tell you what to do. or still sovereign states must say something in response, positive in response to the decisions of international organizations. That's the question which we will be addressing today. In general terms, law, and so we all just deal with law on a daily, hourly basis, a variety of situations, from traffic to the things we do in stores and even inside our homes. It's a rule that's either prescribed or recognized as binding. So prescribed to somebody, an authority just prescribes this rule, or recognized, or we recognize, we accept this rule, and this is binding. So we have to, we must, we should, we shall. International law, almost by definition, is a set of principles, rules, and regulations concerning international relations among states. But in a country in which you live, in a county, in a state, we do have a variety of institutions that represent law, through which law functions. How about international relations? Do we have a global constitution? Most countries have it. Do we have a global constitution for the United States? Well, people say, well, how about United Nations or the chart? And there's a sort of a, well, it's not a global constitution. It's a set of rules that governs this international organization. How about global Supreme Court to adjudicate decisions and make judgments? It is a Supreme Court. Global Supreme Court? No, we don't have it. How about global law enforcement? So somebody violates the law and there's a law enforcement. Every country has law enforcement and it's different institutions that enforce the law. Do we have such? No, we don't. No, we don't. Of course, force is used and there's enforcement, but there is no global police organization. And for those of you who don't know, the Interpol is not a global police organization. Well, they do search and cooperate in terms of collecting data, comparing data, and identifying potential problems. So we don't have those institutions, but why do we have international law? Is it necessary to have international law if there's nothing to introduce in terms of the enforcement, adjudicate process, or to appeal the process? Why do we have international law? We have three reasons why we have international law. We need to have it. First of all, is a need for secure international environment. So that we must understand there must be some common rules, and rules guarantee us safety of movement, safety of living, safety crossing borders. So this must be secure international environment among states. It's vital, it's important, necessary for most of us, all of us. We need conflict resolution. States always disagree on something. One of the most common disagreements is territorial disagreements. Name any country and we'll find out that this country has problems with its neighbors, certain disagreements about where the border should go. And something must be said to help countries adjudicate those disagreements. I use a classical case, a good one. It's of 1990, Yemen, Eritrea. They disagreed about Hanish Islands in the Red Sea, and they agreed to follow the decision of court of arbitration, and they followed. The archipelago was decided to be given to Yemen, and Eritrea accepted the decision. Violence was avoided. So can we do this with all other territorial disagreements? Of course, it's a very difficult question. And also, it's a big one. Third one, a need to coordinate domestic laws in a global world. Coordinate them. Every country has its own legal system. Most countries have codes, legal codes, which, well, those laws are written. United States does have codes, but US system, British system is a case system. And so still laws that exist in the United States, they are written, they are published, and we can refer to them, and other countries have different laws. Think about divorce, think about immigration, think about trademark disagreements, traffic accidents, financial obligations, debts, compensation for faulty products, copyright violations, and custody. Only a small layer of issues that's require knowledge of other countries' laws. And many of you who think about a career of lawyer and you think about doing something internationally, that's one of the things that you will do. You will have to interact with individuals who professionals, lawyers in other countries. You know that it's for you, once again, a very important footnote. Using this opportunity, I should say that honestly, to deal with a foreign country and you help your government, say you work in the United States and you have to just make a trade agreement. You need specialists who are professionals and who are experts in law of that country. And you cannot be the best expert in the foreign country law. It must be that country's national, right? So essentially, you need to know laws of the United States and then understand how to interact with lawyers in other countries. Those individuals who study law in law schools from foreign countries, they usually enter a master's program, study 1 year. So this is the equivalent of a master's program, study US law. For US citizens, certainly law school, it's usually a 3-year program, is what is required. Very few law schools will specifically teach you international law. There are courses you can take, and you can easily check those schools that teach those courses, but it is a very tricky field. If I hear a lot, Professor, I want to become an international lawyer. International law is my field, hopefully my field, and I want to do something in this field. You've got to become lawyer in this country first. You have to go just pass bar examination. So you have to be a professional lawyer, not just a person with a law degree, just because you want to have it. You have to have skills, knowledge, you have to practice law, and only after that you can consider your options in trade, in negotiations, in political issues, in building, rebuilding, helping, and other issues that lawyers can be involved. We'll discuss further opportunities in legal profession. So we need international law, and so I give you several examples here. There are principles which international law shares and or on which it is based, and one of them is jurisdiction. It's very important. It's a right of authority to make decisions and apply justice, in particular territory. You move to Canada, for example, just to see something in Toronto or Montreal. Just you move from US, just you cross the border, and you're in a foreign country. And then the laws are there, and Canadian government, provincial, federal government has jurisdiction in the province in which you are, and not US government. So jurisdiction is very important legal issue, and those who are skeptical about international law suggest that this is it. If countries do have jurisdiction within their borders, other countries don't have jurisdiction within their borders. So that's why they cannot tell you what to do and how you do this. And this is only your responsibility. That's why there is no international law, because it's always within your jurisdiction. However, international law, it has many examples, and mentioned about them today. For example, anti-piracy laws that have been established many centuries ago, and they have universal jurisdiction because they apply everywhere. Countries agree to apply the anti-piracy laws everywhere. Look at European Union, and so they apply their laws across many countries. So European Union. And then the countries have own legal system, and yet certain laws within European Union are mandatory for members of European Union, not for Switzerland, which is not a member, but say for Italy, France, Germany, the Netherlands, Denmark, and others. International law is not just an invention of some smart individuals, men and women, who try to make it happen. International treaties, I'll just explain this briefly, international treaties, agreements between countries. International customary law is under the foundation of international law. The general principles of law, I'll explain, and the judgments of international organizations, courts, tribunals, scholars, and those who write about international law. We begin with international treaties, easy to comprehend. So one country, second, maybe third, maybe fourth, maybe more, maybe only two, they make agreements. And they sign agreements, and they try to, and most of the time they follow what they promised. Rules supposed to be rules, and they're supposed to be in place. That's a lasting nature of international agreements is one of the foundations of international law. That's, again, takes two to agree on something. And well, that's the beginning of international law. It's agreement between two countries, and they do not judge, and they try to not to violate. Many examples of violation and accusations that some countries don't fulfill the obligations made 5, 10, 20 years ago. But at least they agree on something, at least the principle of which they both decided to be loyal to. Second is customary law. What is customary law? Well, custom. So it's about what happened in the past and how it was done. And so countries continue to do the same way. Why? Because it's about predictability. It's about what has been done. It's about stability. So if this has been done, so continue doing this, and we know that's this important rule. Give an example about territorial waters. This is about 12 nautical miles, or about 22 kilometers. Well, some say it's originally the distance of a cannon shot fired from the shore, but you know, it's a cannon don't fly that far, but just in theory, it's how far. And that's continued to be 12 nautical mile zone is territorial waters of a sovereign state. So how about 12 and a half? No, now you're into international waters, but within the territory of that state. So some of my colleagues joke that if you have a wedding, an official ceremony, just taking place within 12-mile zone, just you're on a yacht, on a boat, so that's a legal wedding, right? So if you're just 1 mile further, well, just the international waters, that's the law of a country in which you're supposed to be wed, will not be actually recognized there. General principles of law. Well, so the principles on which law rules, commonsensical rules, most of the time on which law is based. So right of self-defense. You've been attacked, you do have a right to respond. However, your actions must be proportional to the aggression. Makes sense? Well, what makes sense, I think, to many is just stop violence. However, if violence takes place, do we have a right to defend and respond? Well, yes, there's an assumption you have the right, but it must be proportional response. Well, your nationals damage something in another country. My country nationals damage something. My country has the obligation to compensate, and the other country has the right to ask for compensation. So those principles, and so cross-cultural, so it makes sense in every cultural environment. And finally, judgments of international organizations, which we discussed at the beginning of class, and I give you many others. For instance, in 1980, following Israel's decision to make Jerusalem its own capital, UN Security Council declared, passed a resolution which stated that Israeli law was in violation of the international law. And well, in part because of this resolution, most foreign embassies in Israel remain in Tel Aviv still. So they follow the practice. Of course, they have different visions about what they should do without any opinion of the national organization, but knowing that's what's the opinion of the country, decision of the UN, they try not to move capital embassies from Tel Aviv to Jerusalem. And there are other judgments, other decisions, other adjudications, other rulings that countries decide to choose. Notice, countries decide to choose and use in their action. So it's a goodwill still there. Lots of power in international law is based on the goodwill and collective actions. In the textbook, please read pages about the history of international law. they're quite detailed, and so we'll skip through them just to leave you this chance to read the pages about how it was developed and how the steps were made. So to decide on borders, then to decide on navigation across the seas, anti-piracy laws, territorial water, navigation, freedom of navigation, how countries would justify their colonial expansion, declaring lands belong to no one, terra incognita, just the land belongs to unknown lands, and lands just belong to no one, just you can write to occupy or control. Terra nullis, just land belong to no one. So terra incognita is unknown land and become terra nullis. Nobody owns the land. So that's why you have a right to possess this land. Then international telegraph and telephone and postal service. You may wonder just how it was happening in the past. You write a letter in France and you just seal an envelope, put a stamp and send it to Japan. It will arrive there. How? Well, because of agreements that our ancestors were able to sign back in 1800s about how to treat those letters. You put a stamp in your country and it's just treated in the other country. So that's international agreements, the law. So it's how countries operated. And so that was part of a normal routine. And then telephone and then television, and now, of course, many other laws that you can read about, including laws of war. Just the countries began to more often 120 years ago, just and later began to take steps to limit the destructive power and killing power of military conflicts. And it was a tedious process, long process, but the process had started that's a century plus years ago. So please read about this. But here we'll quickly review what politicians and scholars said about international law. Predictably, realism has not been very warm and really accepting international law. By definition, realism is emphasizing the power of individual states, right? And so that's why it's not surprising. International law should not undermine country sovereignty. Yes, countries can agree on things. However, your country A, their country B, you think that your agreement was, this agreement is not really beneficial to your country. You inform them that you're out of this agreement. And this is your right to do. So that's a very important point. International law is ineffective without proper enforcement. True, and enforcement's supposed to be. We sign a deal, 5 of us, and 2 countries just completely ignore. So what do? Just you say, well, it's poor luck. Or does you have somehow just force them to follow the agreements. In our legal system, it's just you can do this, just legal procedures. You can, if say a company didn't fulfill the obligation, you can file a complaint. So through administrative means or legal means, you can just somehow pursue your goal. What do you do in the national environments? Realism says that's basically it. Either you use a force against them, but otherwise just you can make laws work, and that's why do we have them? Just if we still may not use force, we should. And next, countries have no higher legal authority above them. That's repeating postulates of realism. There's no higher legal authority. Yes, there's stronger powers that can use arguments and persuasion in reasoning, but there is no legal authority. Even the UN still is an organization which is based on the goodwill of countries. If I don't like what they decided, that's their problem, not mine. I'm just giving you a very simple and simplistic description of realism. And I explain these principles again on this slide is to help you. Sovereignty, state interests, and law enforcement. 3 things that may be applicable to international law, and only on those conditions international law is supposed to work. It worked in the past through mandates. Realism understands it. Yes, you can issue legal mandate. So legal right to a country which will be used to act in foreign policy. And treaties of guarantees. So it's you, a third party, you discuss with two others their disagreements, and you become sort of an enforcer of the agreements. Case in point about mandates, the division of the Middle East and North Africa after 1919 Court in Paris. So it's a League of Nations established those mandates, legal rights for Britain and for France to essentially control portions of the Middle East. Well, if Russia didn't turn communist, it would have had also mandates. The idea was that Russia would control parts of contemporary Turkey. So that would say, in particular, Istanbul and other parts. But Russia just turned away and didn't want to deal with this. And so that's why Russia wasn't the player. Here we go. Mandates. United Nations or League of Nations or any international body gives the right to a country to administer something, and that it's a temporarily and also has limits. Treaty guarantees are famous agreement when Britain would be a judge of both parties, Greece and Turkey, over problems on Cyprus. Cyprus has a mixed population there, and historically things have been stable and unstable. And to make them stable, British government was one who just was fulfilling the Treaty of Guarantee, just was a judge. So this is what realism accepts. See, there are roles, and there are roles to be played. So realism doesn't deny the existence of international law, but says it's just quite limited. As you expect, a liberal point of view is quite different. Liberalism is, by definition, is about international agreements, about new environment, saying that, yes, we're sovereign states, but when we act together, we create a new environment. And we need to deal with this environment through agreements, not through force or diplomacy or secret deals or balancing power. Just we need to create our rules by which we act together. In violation of a rule, this will harm everybody. That's why we have to have those rules. So we have to be governed by shared principles, and that's why we do have to have good relations among ourselves. So, and if we govern by shared principles, we continue to maintain those good relationships. So it's reciprocal. Yes, we have to have international institutions, which are instrumental in international law. Bodies, collective bodies, you elect representatives, you appoint individuals, and they decide on behalf of countries. So it's sort of a republican system, not political republican, democratic, but republican. So you delegate authority through your individuals to decide things, and they decide, and we agree on things. In the best way, this is how UN acts. They have a problem, all countries negotiate, the ambassadors, and they make decisions, and not maybe the perfect for everyone, but at least countries agree on something, and through compromises and dealing, they move forward, like as if you work in your county, in your jurisdiction, in your state, in your school. And final principles of extraterritoriality, supranationalism, and universal jurisdiction. These are most advanced principles. The first two, we understand that these two need to be explained to you. And so we'll begin with the principle of extraterritoriality. Remember jurisdiction, which I emphasize, saying that that's a key principle of any law, and the countries have jurisdiction over their own territories. And the picture just shows yours truly in front of U.S. Embassy in Poland. It's Warsaw, capital of Poland. And as a U.S. citizen, so it's I will enjoy my rights, and Poland's European Union country. But if I jaywalk to embassy, I can be stopped because of its violation of Polish rules. However, because being a U.S. citizen, I don't think they will be really after me, because it's difficult to adjudicate my case, and because I'm U.S. citizen. So that's a difficulty, and that's what jurisdiction suggests. And this is what the opponents of international law say, or those who are skeptical about it. Well, it doesn't work. Every country has own rules, and just you cannot reconcile them. Just simply deport a person. Maybe what you can do. However, history knew many examples that in the past, such as merchants from Genoa, Venice, traveled to Istanbul, and they were exempted by Ottoman rules from following Sharia. Basically, yes, don't kill and don't steal, but practice your own rules. You're welcome, but well, for economic reasons, you're welcome, and so you're welcome to trade. It's interesting. So the countries would make exemptions. So that's why it's possible for laws of countries to interact, because exemptions can be granted and can be offered. Treaty port system in China, Japanese coastal cities too, opened special zones. Westerners could live under British and French law. Reluctantly, in most cases, those zones were opened, but for economic and political reasons. So just direct exemptions, of course. And the third principle, a third example, Americans who live in China under a combination of US, European, and local ordinances. And today, extraterritoriality applies to heads of states, diplomatic missions, and foreign military bases. So many examples which suggest that laws can interact. And a country doesn't have absolute sovereignty of, or rather jurisdiction. Yes, sovereignty is true, but jurisdiction of everything. No, there are exemptions. And the more exemptions we make, the more interactive cases we create because of a business, because of education, because of sports, because of the exchanges and temporary visas. There we go. We can have this system which will be different from the system of rigid jurisdictions that existed for centuries. So extraterritoriality is a principle, liberal principle, which suggests that the more extraterritoriality is developed, created, the more international law, the stronger it becomes. Supranationalism, that's maybe easier to explain. It's another sort of a feature of international liberal view of liberalism. Its view on international law. Supranationalism, the delegation of authority from sovereign states to international institutions, organizations. And one of the best examples is European Union. History of human civilization is especially past 300, 400 years, is a history of a struggle for sovereignty. I, mine, ours, just not yours. So you bring fences and you declare it's your territory, and you exercise your power within territory, establish jurisdiction as a king, as a sultan, as a tsar, as a president, as a prime minister. Supranationalism is giving it up. See, maybe for the first time in history, at least profoundly, countries simply said that we will give up some of our sovereignty on behalf of our collective identity. And there we go. We have the European Union. The ups and downs, the difficulties, but the system had been established and had been successful for many years now. Again, those organizations can share principles, can be expanded, and is needed to expand it or modify. Think about East African Community. It's an experiment which is continuing, and the mixed results, but it's process right there. Several countries in East Africa decided to work together on common labor policies, financial policies, defense policies, to save money, educational principles, communications, and others, and other principles. They follow the footsteps of European Union and learn from Europeans' mistakes and build their own system. Supranationalism. And universal jurisdiction. Controversial principle, which many, especially those who fight for rights of individuals, like, and many authoritarian leaders dislike and hate the principles. This means that those dictators, those individuals who are responsible, and even we think they have been responsible for crimes committed against their own people. And crimes include crimes larger scale, so it's murders, and torture, and blatant cases of discrimination of people's rights. So these individuals cannot enjoy just immunity whenever they travel. So jurisdiction principle is, remember, you commit a crime here and you must be tried here. This is where you are. It can be just detained in Hawaii if you're in Virginia. If a crime committed in Virginia, or something happened in Argentina, well, you can be detained in South Korea. Now this principle says you can be detained, and you may be detained, because this is how system works. So there are higher principles based on which you somehow suspend the power of a country or a person's immunity. What do you mean by immunity? So a case of former president of Chile, Augusto Pinochet, who was detained in Spain based on the charges, this is his violation of human rights in Chile. So a person from Chile, something was committed there and charges were filed, and he was detained in Spain. He had good lawyers and he was released, but this, the very fact was relatively new. We can dispute the cases and discuss what is it, too much of international law, or whether or not values can trump or overpower legal principles or not. But many individuals suggest that this in the future could be a very important development of international law. Second case, Slobodan Milosevic, former president of Yugoslavia, autocratic leader. Well, he also just couldn't simply claim that well, I'm traveling and I'm untouchable and I supposed to be tried. If you think I'm guilty, I'm supposed to try it my homeland. It didn't happen. And for many years, former leader of Sudan, Omar al-Bashir, well, he was charged of human rights violations in his country, and yet he was banned from travel in many countries, except for Africa, but for most countries all countries in Europe and the Americas and other countries. Just basically, this was ordered for his arrest because of crimes committed, alleged crimes committed in the Sudan, his country, but he no longer president. Predictably, constructivists pay attention to ideology and perceptions, suggesting that international law exists. However, we must understand it not because once and for all equally, which is supposed to be, right? Law is supposed to be blind, justice is supposed to be blind. It's just you've done it or you didn't do it, and we decide, and we adjudicate cases, and we use principles and codes and procedures. Well, constructivism suggests not principles and procedures and codes written by people, and people have different views, religious, political, cultural. People have different perceptions, different memories about what had happened, and define things differently. I'll give you very simple examples about people in the past, when they try to change international system, they try to change the legal foundation of the system, and the principles in which countries operate. Napoleon and his wars in Europe, or his goal was to crush the old system of monarchies and create new system of different countries. Of course, France wanted to play a bigger role there. Soviet communists, when they took over in 1917, they just cancel all international agreements by their predecessors, by the emperor and emperors in the past, saying that's it, we don't recognize their power, they're gone, just we completely free of obligations from other countries. We change the system completely because we don't recognize the system. Al-Qaeda for many years just believed that international treaties for most countries in the Islamic world not valid. Presidents can sign as many deals as they want, but it will be un-Islamic and therefore just not supposed to be followed. And just that gave those individuals like Napoleon, Lenin, or Al-Qaeda just the right to not recognize the system, saying I'm not a part of it, and why should I obey? As if you and I now say, okay, I don't recognize this law, and I can drive 55 anywhere I want, despite the sign of 25, because I don't recognize this county ordinance or rule of a state. Federal law, I don't recognize it. That's why I can't violate this. And that's what probably will be stupid and irresponsible to do in specific conditions. So county in which I live and state in which I live, in which you live. But internationally, it has been done, it is being done continuously. So these countries don't like the law, don't like the system, and say we're not part of it. And then what do you do? What do you do? Then real politics says one, and liberalism suggests something else. In conflict theories, of course, suggest that we must understand the law as not just an abstract just construct. It's something which plays a role in fulfillment of interests, either corporations and banks, big international organizations. New bureaucracy grew, and now they overpower sovereign governments. That's a point of view which is very powerful, suggesting that new bureaucracy is, in fact, the ruler of the world today, not sovereign governments, that global bureaucracy, and they're afraid of giving power to international organizations. Well, Western power and their satellites, Western powers, it's idea that it's international law written by Western states. And so the whole international system is based on the interest of those Western powers, mostly white and mostly colonial powers in the past, and that's the international system today. And this must be changed because the core system is wrong. That's a very powerful point of view. And also, remember, feminism of the international law, despite all the good things that it brings, and other nice things you can say about international law. It's a law which serves masculine culture, essentially, and written by men, mostly by men, and serve interest of men, just to promote their masculine culture. It should be completely overhauled, or at least major points of systems supposed to be overhauled. Well, this is again very short description of those approaches. You can read them in the text. Concluding case in point, I'll tell you about how law has been applied in the past is a case of Nuremberg Trials. Nuremberg Trials, many things written about these trials, and you also can find information in the text. But this is one of the classical cases which gives you ideas and food for thought about the strengths of international law, and also about the law weaknesses. And plenty of strengths, plenty of weaknesses. When the war, which was the most devastating war in the history of humankind, which when the war was close to the ending in February of 1945, and later, leaders of UK, United States, and USSR also was a victim of German aggression, and it suffered a lot. So the Russians and Soviets were allies, the United States and UK. They agreed to hold former Nazi leaders, leaders of Imperial Japan, responsible for crimes against humanity. What crimes? It's aggression, it's mass deportations, killings, ethnic cleansing, just attacks on civilians, concentration camps, and Japanese generals and officers did, and in China and Korea and Vietnam and the Philippines, and what the Nazi Germans did all over the world. So this, for those crimes and for those orders, they can be tried, and there was a decision made. But how can you try individuals in a foreign country? And you're Americans, you're French, you're Russians. Because how can you just adjudicate somebody in Japan? It's just it's nonsense, right? It's international law. Well, that doesn't even suggest anything anything about this. You can say this, but what they did was interesting. They agreed that just German governments and Japanese governments also, they lost their authority. So they've been just defeated and gone. So therefore, the government doesn't have jurisdiction of a territory of Germany and Japan. And so therefore the victors, those who win, they establish the jurisdiction over the country temporarily. And then they will be adjudicating everything for the crimes, the thing that individuals committed. Interesting about Germany. So the court would have jurisdiction only over crimes that took place after the start of the war, but not before, but only after the beginning of the war, of that war. And what happened there became known as Nuremberg Trials against Nazi criminals or alleged criminals, let's put it in the right legal way, and later Tokyo trials against the individuals in Japan. And the charges were against them: conspiracy to wage aggressive war, crimes against peace, war crimes, profound violations of the laws of war, and the laws of war being designed in the beginning of the 20th century, and crimes against humanity, action in concentration camps and occupied territories in Europe. It is for Nazi suspects, and then Japan against the territories. It was referring to territories in Asia. And well, they created legal precedent. So we can find some cases in the past, but very few. This was a profound case and a new legal precedent. So ruling that international courts may develop in future prosecutions. So that's, you gather judges, you gather lawyers, you gather witnesses, you gather experts, you gather individuals simply just who want to be part of a system and want to make judgments on behalf of other people, like a jury members. And they decide on cases which in theory don't have jurisdiction, or cases or decide institutions that don't have jurisdiction on those cases. And this is, again, the expansion of international law. The opponents of law, critics, suggest that that's arbitrary. How can you even know that? So if you know the evil people, they committed terrible crimes, but legally it's just very, very weak case, because foreigners come and try. It's not really legally possible. Others suggest maybe this is the only way. It was possible. It's the only way how to well, seek and find justice. And this is a case which gave a lot of impulse to many other cases. On this slide, I showed to you that's again laws that's been passed beginning of the 20th century, then consensus about international actions against war crimes, and then atrocities themselves that were awful and they play a major role in many people's development of many people's values and understandings of life and peace, and politics, and then trials. They gave sort of impulse to the creation of a variety of institutions in the world that's play their role, maybe not the most effectively what they do it, but still they play a role in terms of monitoring, observing, making decisions, and doing everything possible in their power to stop such atrocities in the future, which unfortunately continue in many countries. Think about Syria, think about many other parts of the world, just and slaughter of people and use of chemical weapons and concentration camps, and a variety of things that are being done. And again, this is something we will look at when we study human rights, but this will be in the future. So this is all for today about international law. Thank you for your attention. As always, don't forget that's the practice questions referring to today's lecture. Next time, we will review international political economy, how states and international organizations and NGOs create, distribute, consume products and services. So, but this will be about economic issues. So thank you for your attention. I'm Eric Shiraev, and I will see you soon. Thank you so much.